accused of stealing from my mom. But the judge changed everything. I was sitting in a courtroom, being called a thief, by my own family. How does a person end up defending themselves against their own blood? What they didn't know was that I had saved every single receipt, every bank transfer, every text message, for 3 years. And when the judge asked my sister to explain one specific transaction, the whole room went silent. Because it wasn't me who had been stealing. It had never been me. I'm Declan, 41, a former logistics coordinator from Columbus, Ohio, and for the last 3 years of my life I have been called a thief, a manipulator, a fraud, and a predator, all by members of my own family, all in reference to the same woman, my mother, who has Alzheimer's disease and who I moved in with in the spring of 2021 to take care of full-time. Let me set the table before I get into it, because context matters here, and I'm not going to let anyone walk away thinking they only got half the picture. My mother was diagnosed with early-stage Alzheimer's in late 2020, at 71. My father had passed 4 years earlier, cardiac event, sudden, no warning, and after his death, my mother had been living alone in the house they'd owned together for 38 years in Westerville, a suburb of Columbus. She was managing fine until she wasn't. The disease moved faster than the doctors initially projected. By early 2021, she was leaving the stove on, missing medication doses, and had gotten lost driving to the pharmacy she'd used for 15 years. I am the oldest of 3. My sister, 4 years younger than me, lives in Scottsdale, Arizona, with her husband and 2 kids. My brother, 7 years younger, lives in Nashville. Both of them have careers, mortgages, children, busy lives. I was the one without kids, the one between jobs after a company-wide layoff, and the one who lived 40 minutes from mom. So I moved in. I gave up my apartment, put my furniture in storage, and became my mother's full-time caregiver. No salary. No formal arrangement at that point, just a son doing what he thought was obviously the right thing. That decision, made out of love and logistical common sense, is the thing my sister would later try to use to destroy me. The first year was hard in the way that caregiving is always hard, relentless and invisible. My mother needed help with medication management, meal preparation, hygiene, appointments, finances. I became, by necessity, her everything. I coordinated with her doctors. I handled her bills. I managed her bank accounts, with her knowledge and consent, and with a durable power of attorney that her elder law attorney drafted in March of 2021, while my mother still had sufficient legal capacity to execute it. That POA was drafted by a licensed Ohio attorney. It was properly witnessed and notarized. It named me as her agent for financial and healthcare decisions. My sister and brother were both notified in writing by the attorney's office at the time it was executed. My sister did not object then. She did not fly to Columbus to be present. She sent a text that said, "Okay, keep us posted," and went back to her life in Scottsdale. For the next 2 years, I kept them posted. Monthly email updates, my mother's health status, her medications, her appointments, quarterly financial summaries, income, her social security and a small pension, expenses, utilities, groceries, prescriptions, home maintenance, my mother's personal spending. Everything documented.
Everything transparent.
My sister replied to approximately 1 in every 6 of those emails. My brother was more engaged. He called my mother every week and visited twice a year, and he and I had a functional, honest relationship throughout. He helped when he could. He was not the problem. In the spring of 2023, 2 things happened in close succession that changed everything. First, my mother's condition declined significantly. She moved from moderate to severe stage Alzheimer's over a period of about 3 months, faster than her neurologist anticipated. She became largely nonverbal, required assistance with nearly all daily functions, and was at the point where her care needs were exceeding what one person could safely provide alone. Her doctor recommended transitioning to a memory care facility. Second, my sister announced she was coming to Columbus, not to help with the transition, not to see her mother. She called me on a Tuesday night and told me she'd been doing some research and had some concerns about how my mother's finances had been managed, and that she was flying in that weekend with her husband to go through everything. I said, sure.
Come? Y ella have everything ready for you.
I wasn't worried. I had everything documented. I had 3 years of records organized in binders and backed up digitally. Every transaction, every receipt, every invoice. I had spent 3 years being meticulous specifically because I knew that managing a parent's money while living in their house is the kind of thing that looks suspicious to people who aren't watching it up close. My sister arrived on a Saturday. She brought her husband, which I noted but didn't comment on. She did not hug our mother when she walked in. She went directly to the kitchen table and said, "Show me the accounts." I showed her everything. She spent 4 hours going through the records. Her husband sat next to her and occasionally made notes on a yellow legal pad. My mother sat in the living room with a home health aide I'd arranged for the afternoon, watching television. At the end of 4 hours, my sister pointed to a line item, a $4,800 check written in November 2022, and said, "What's this?" "Furnace replacement," I said. The original furnace failed. I have the invoice from the HVAC company and the warranty paperwork. "You wrote this check to yourself first," she said. "No," I said. "The check was written to Bauer Heating and Cooling. That's what it says on the memo line. You're looking at the wrong column." She flipped the page. Said nothing. She found 3 more items she characterized as questionable. A $1,200 expense in April 2022. A $900 expense in August 2022. A $2,100 expense in January 2023. All 3 had documentation. The April expense was a plumbing repair. I had the invoice. The August expense was a new refrigerator after the old one failed. I had the receipt and the delivery confirmation. The January expense was a week of respite care I'd arranged so I could deal with a personal medical issue of my own. Documented, invoiced, completely standard. She looked at all of it. She sat with it for a long moment. Then she said, "I'm not satisfied." I looked at her across my mother's kitchen table and said, "What does that mean?" "It means I'm going to have an attorney look at this." She hired an attorney in Columbus within 2 weeks. That attorney sent me a formal letter demanding a full accounting of all financial transactions related to my mother's estate since March 2021, and asserting that my sister had reason to believe that I had misappropriated funds from a vulnerable adult. In Ohio, misappropriation of funds from a vulnerable adult, specifically an adult with a documented cognitive impairment, is not just a civil matter. It can rise to the level of criminal elder abuse under Ohio Revised Code 2903.341. The letter from her attorney made clear that she was considering reporting the matter to Adult Protective Services and potentially to law enforcement. I called my own attorney that same day. My attorney, an elder law and probate specialist in Columbus, reviewed my documentation and told me, bluntly and with evident confidence, that my records were some of the cleanest he'd seen in a disputed POA case. He said, "Whoever kept these records knew what they were doing." I told him I'd kept them because I'd always known this day might come, not because I expected bad faith from my family, but because I understood how these situations could look from the outside. He told me to stop communicating with my sister directly and to let him handle it. I did. What happened next took about 4 months to fully develop, and I'm going to walk through it in the sequence it actually occurred, because the sequence matters. My sister filed a complaint with Franklin County Adult Protective Services in July 2023, alleging financial exploitation of a vulnerable adult. APS opened an investigation. An investigator visited my mother's residence. By this point, my mother had been transitioned to a memory care facility, a process I had managed and documented fully, and interviewed me, reviewed my records, and interviewed the home health aides who had worked in the house. The APS investigation was closed in September 2023 with a finding of unsubstantiated. The investigator's notes, which I later obtained through a public records request, described my documentation as thorough, and found no evidence of financial exploitation. My sister's attorney then filed a petition in Franklin County Probate Court to remove me as POA and appoint a professional guardian and conservator to manage my mother's affairs. This is a legitimate legal mechanism. Ohio probate courts have jurisdiction over guardianship and conservatorship proceedings, and my sister had standing as a family member to file it. The petition alleged that I had engaged in self-dealing, that I had benefited personally from my position as POA, and that my mother's financial interests would be better served by a neutral third party. We went to court. The hearing was scheduled for November 2023 in Franklin County Probate Court. My sister flew in from Scottsdale. Her husband came again. They brought their Columbus attorney, a man who clearly specialized in looking confident in courtrooms. My attorney and I sat across from them. I had brought 3 binders, color-coded, indexed. The magistrate overseeing the initial proceeding asked my sister's attorney to present the basis for the petition. He walked through the 4 items my sister had originally flagged: the furnace, the plumbing, the refrigerator, the respite care, and suggested they represented a pattern of self-dealing. My attorney responded by submitting documentation for each item: invoices, receipts, third-party confirmations, the HVAC company's business license, the plumber's invoice with his contractor number, the appliance store receipt with the delivery address listed as my mother's home, the respite care invoice from the licensed agency. My sister's attorney pivoted. He argued that even if the specific items were documented, the overall pattern of my having access to my mother's accounts for 3 years without adequate oversight was itself problematic. The magistrate asked my sister directly, "Did you receive the financial summaries your brother sent?" My sister said, "I received them, but I didn't have the expertise to verify them." The magistrate said, "Did you request any additional documentation or verification at any point during those 3 years?"
Pause.
"No," she said. "Did you raise any objections to the power of attorney when it was executed?"
No.
"Did you visit your mother in Columbus at any point during the 3-year period your brother was serving as caregiver?"
Another pause.
"Longer this time. I visited twice," she said. "And during those visits, did you observe anything that concerned you regarding your mother's care or finances?" "Not at the time," she said quietly. Then came the moment I want to describe carefully, because it's the moment that changed everything in that room. The magistrate, a woman in her 60s with reading glasses and the kind of patience that only comes from having sat through thousands of family disputes, asked my sister's attorney if there were any additional items beyond the 4 that had been identified and documented. He said yes. He had one more. He submitted a document to the court, a transaction record showing a $7,500 transfer from my mother's savings account in June 2022. He said this transfer had not appeared in any of my financial summaries and had not been accounted for. I looked at my attorney. He looked at me. I had no idea what they were talking about. A $7,500 transfer in June 2022 was not something I had made. I told my attorney this in a whispered exchange, and he asked the court for a brief recess to review the documentation. During the recess, we looked at the actual bank record they had submitted. The transfer was real.
7,500 pesos, June 14, 2022. Wire transfer out of my mother's savings account.
It had not gone to any expense I'd made. It had not gone to any vendor or service provider. It had gone to a personal bank account. We requested the full wire transfer record from the bank, which my attorney was able to obtain quickly because I remained the authorized agent on the account. The receiving account belonged to my sister. We reconvened. My attorney presented the wire transfer record to the magistrate. He laid it out without drama, just facts. The June 14, 2022 transfer of $7,500 from my mother's savings account, the receiving account number, and the account holder name. My sister's name. The courtroom did something I can only describe as holding its breath. The magistrate looked at my sister over her reading glasses for a long moment. Then she said, "Counsel, can your client explain this transaction?" My sister's attorney asked for a recess. It was granted. They were gone for 35 minutes. When they came back, my sister's attorney said his client had made an inadvertent error in judgment and that the funds had been intended as reimbursement for travel expenses related to caring for her mother. The magistrate said, "Was this transfer authorized by the power of attorney holder?" No. Was it documented in any accounting provided to the family? No. Was any request for reimbursement submitted to the POA holder prior to this transfer? No. How did your client access the account to make this transfer? This was the question that unraveled it completely. Because the answer, which came out over the following 20 minutes of increasingly uncomfortable questioning, was that my sister had retained a copy of my mother's online banking login credentials from a period before I took over financial management, credentials my mother had shared with her years earlier, casually, the way parents do, and had used those credentials to initiate the wire transfer without my knowledge, without my mother's meaningful consent given her cognitive state, and without any documentation or authorization under the POA. What my sister had done, accessing a vulnerable adult's bank account without authorization and transferring funds to herself, was, under Ohio law, precisely the thing she had accused me of doing. Ohio Revised Code 2913.02 covers theft. Ohio Revised Code 2903.341 covers patient abuse and neglect, including financial exploitation of a vulnerable adult. My attorney noted both in his subsequent written filing. The magistrate denied the petition to remove me as POA. She issued a written decision 3 weeks later finding that my management of my mother's finances had been appropriate, well-documented, and consistent with the duties of a fiduciary agent, and that the petitioner had failed to present credible evidence of misappropriation. The $7,500 transfer was referred to the Franklin County Prosecutor's Office. My sister was criminally charged. In Ohio, theft of $7,500 from a vulnerable adult, an adult with documented Alzheimer's disease who lacked capacity to authorize the transaction, is a felony under ORC 2913.02, elevated by the Vulnerable Victim Specification. She was charged with felony theft in January 2024. She ultimately pleaded guilty to an amended charge of misdemeanor theft. Her attorney negotiated it down, and was sentenced to 2 years of probation, ordered to repay the $7,500 in full, and required to complete a financial crimes diversion program. She did not go to prison, but she has a criminal record. In Arizona, where she lives, that conviction is publicly accessible and has affected her husband's professional standing. He works in financial services, and a household member's theft conviction triggered a compliance review at his firm. I did not pursue additional civil damages. My attorney advised that I could, and that I had a viable case.
Y chose notó.
Not out of mercy for my sister, exactly. More because I was exhausted, because my mother was in memory care and declining, and because I had nothing left to prove to anyone. My mother is still in the memory care facility. She no longer recognizes me consistently. There are days when she calls me by my father's name, and I don't correct her, because it makes her happy and it costs me nothing. I visit 3 times a week. I still manage her finances. I still send monthly summaries to my brother, now because he asked for them and because I am still the kind of person who keeps records. My sister has not contacted me since the guilty plea. My brother and I have talked about it, carefully, with a lot of pauses. He said once, "I don't know how you didn't lose your mind." I told him the records kept me sane, that having something concrete to point to, something that existed outside my own memory and my own word, was the thing that held everything together. He nodded. He said, "She's our sister." I said, "I know." We left it there. I'm back to working. Took a supply chain consulting role that lets me work partly remote, partly from the memory care facility's family lounge on my laptop while my mother sleeps nearby. It's not the life I planned. It's not nothing, either. If you made it all the way to the end of that, the courtroom, the wire transfer, the moment my sister's attorney ran out of answers, then you have the same fundamental inability to leave a good story unfinished that I apparently have in real life. Subscribe, because the next one involves a forged will, a storage unit, and a cousin who thought no one was paying attention. Spoiler. Someone was paying attention. Someone always is, I need to know. When that wire transfer record came back and the receiving account was in his sister's name, what were you feeling? Because I was sitting here thinking about every accusation she had made, every legal filing, every trip from Scottsdale with the yellow legal pad husband, and it all just collapsed in one document. Tell me in the comments, would you have pushed for the civil suit too, or did he make the right call by walking away? And if you've ever been the person in the family who actually showed up while everyone else lived their life from a safe distance and then had opinions, subscribe, because every single story on this channel is for you.